And we're live.
All right. Good morning, everyone. Welcome to Senate Judiciary, our first meeting of the session. It's good to see everyone, and everyone looks bright-eyed and bushy-tailed and ready to go. And I know I am. I'll tell you that. I want to start off this morning just with a couple of reminders. Now that we're into session, it's a little more formal than we operated throughout the interim. We expect the proper decorum and professionalism. I know we won't have any problems this morning looking out across the room, but we do have some protocols that we expect the proper decorum. So a reminder that we are being live streamed, so be careful with your side conversations. They might be picked up somewhere and sent out across the world. So good morning, everyone. Anyway, Pierre, would you take roll, please?
Senator Case,
He's excused.
Senator Cooper,
Here.
Senator Furphy,
Here.
Senator Schuler,
Here.
Chairman Landon.
Here. Thank you very much. So this morning, let's get started on Senate File 35, Public Records, Department of Corrections Investigations. And Director, if you'd come on forward. This is all three of these bills this morning. Everyone, we have worked throughout the interim, done quite a bit of work on these. So I don't think there'll be a terrible surprise to anyone. But Director, take us away on Senate File 35. Good morning.
Good morning, Mr. Chairman, committee members. My name is Dan Shannon. I'm the Director for the Wyoming Department of Corrections. And to my left, I have Major Tim Ricel, who leads up the Investigative Service Unit. Mr. Chairman, with your permission, first of all, thank you for the privilege of letting me be here this morning. And with your permission, I made myself some notes. It won't take more than probably 5 to 6 minutes, if that's okay.
Please take it away.
Okay.
You bet. As long as you don't go 50 minutes on a lecture or anything, we're good.
Committee members, Mr. Chairman, committee members, I'm here today to address statute 164203, or proposed Senate File 35. The Public Records Act contains exceptions for grounds which deny the rights of inspection of public records. Specifically, the Wyoming statute 164203 states that a custodian may deny the right of inspection on the grounds that disclosure would be contrary to public interest. The statute specifically references records of investigation conducted by or the intelligence, information, or security procedures of any sheriff, county attorney, city attorney, the attorney general, state auditor, police department, or any investigative files compiled for law enforcement or to prosecution purposes. I'm not aware of any other Wyoming agency whose core principles and values require more security procedures or intelligence information in the Department of Corrections. I'm asking for your consideration the Investigative Service Unit only to be considered as described in Senate File 35, not the Department of Corrections. I want to reemphasize this is for the purpose of intelligence information, security procedures, and prosecution purposes only. Even if approved, it would only provide a limited scope as all documents are available for judiciary review. We have no interest in hiding transparency, But what it would provide the opportunity through a judicial review is an in-camera review where we could try to clearly state if there was a security example at that time. We are an agency founded on many principles, but the most important being public safety and trust. We're responsible for the incarceration felons and the individuals on supervision throughout 23 field offices, 5 state correctional facilities, and contracted agencies. Our vision of public safety is broad and includes more than what we supervise. It includes the staff that leave our workplace every day to live in the same communities they strive to protect, the victims of crime, and the citizens of our great state, as well as the family and friends of those affected by incarceration. In furtherance of the public safety mission, we believe it's critical department in the ISU, given the work that they do, to have equal safeguards as other post officers by protecting the most sensitive investigative, gang, and intelligence information. As previously testified, I'm only looking for protection of the DOC documents and only under the ISU investigative, gang, and intelligence records. I'd like to put this in perspective. The Department of Correction generates over 1,000 incident reports a year, all of which required some level of review, and many require investigative efforts. I went back through 2023, less than 7% even rose to the level of a review of that investigation by the ISU, and criminal activity were submitted to, and all that criminal activity was submitted to prosecutors as well as the Wyoming Post Commission. Although the DOC is one of the state's larger agency, the ISU is made up of only 4 post-certified investigators, 2 of which are polygraphers, 1 gang intelligence manager, 2 K9 officers, and 1 intelligence analyst who is stationed at the DCI Intelligence Center. With an average tenure of 16 years per officer and over 18,000 hours of training, they're very well qualified. And I would ask, at least like to say, comment, why does the Department of Correction even have this ISU? It was because of a summary judgment over 20 years ago, because at that time the department failed to provide a reporting mechanism that was safe for inmates and for those who confine, as well as those who interact with those individuals who are incarcerated or on supervision. So we were court under a federal mandate to provide this agency, this department within our agency, that provided individuals a reporting opportunity that people could be protected. When the ISU redacts records are released, unless we deny all the records, they are typically unredacted information contains the investigation purpose to pose a safety risk. Even when we comply with the state's position of transparency through redaction, interference can easily be drawn and cause safety concerns. By redacting information, inmates are left to fill in the blanks, which is a greater concern, as inmates can request these documents as public requests. They are citizens as well. This information has resulted in many inmates being required to be transferred out of state, as well as many who refuse to report any form of contraband out of fear of harm. It's crucial for the Department of Corrections to have the discretion when releasing information pertaining to investigative, intelligence, or security procedures from the ISU. The ISU's investigative and files are not protected like records under statutes 164203. It's my belief this is a direct result that the law was enacted prior to the DOC's uniformed staff becoming post-certified in 2007. So I think that's where the hinge pin was. The ISU is made up of post-certified investigative staff who report directly to my office, and that is by design. It's the best practice standard and allows them to work independently without influence. The agency and counsel on this unit to provide impartial and influential facts to my office to make informed decisions. Beyond the DOC, the ISU coordinates investigations and intelligence information regionally, and I think you may be surprised by this, through other law enforcement agencies as well as federated partners. We support prisons, probation, parole offices, contract agencies, as well as local law enforcement as needed. The ISU is also the hub of the intelligence via our contract, where we work closely and have employees right in our DCI center. Often, our ISU is requested to conduct outside agency investigations and provide assistance. They have conducted investigations for A&I, the Liquor Division, Public Defender's Office, Military Department, and other law enforcement agencies. During Governor Gordon's State of the State discussion, you may have heard him comment about corrections supporting the Texas border. we're short-staffed in our institution. So we were asked to send a specialized unit, and it was our ISU troops that went down for investigations and canine detections. Some DOC records are protected, and I think we have a really good public record on how we do protect these records. Wyoming Statute 719-101 through 103 protects criminal history records. 713-49 protects probation and parole records and states all information and data obtained in the discharge of official duties by probation and parole agents is privileged information. It shall not be disclosed directly or indirectly to anyone other than the judge or department receives reports thereof. The staff is also required by policy to investigate serious matters within probation and parole. Thus, a discrepancy exists between the agent conducting the investigation and the ISU. Additionally, we find the discrepancies between investigations conducted at county versus state prisons. And I'll provide an example. If the exact same incident takes place at a county jail, it's afforded protection under the statute. However, the same type of incident may occur in a prison and be investigated by the ISU is not protected. The exact same crime at Goshen County Jail takes place as Wyoming Medium Correctional Institution. One's protected, one's not. With the heightened level of gang violence and intelligence systems compared to county jails, this is really surprising to me. I fully support transparency and understand that corrections is built on public trust, but we must not sacrifice the safety of the public, those we supervise, or our staff. In testifying before you today, I ask nothing more than that of other post officers. The DOC will continue to provide transparent information to the public, but it's a very specific request. I ask in conclusion for a very specific unit to be exempted, a unit that's the same as the other entities included in the current statute. This is based solely upon security intelligence information. In 2023, we received 423 public information requests. Of such, 18% was from non-incarcerated Wyoming residents. The remaining balance was from incarcerated individuals, those on parole, as well as out of state. Lastly, I made myself a note, there's no fiscal impact upon this request. However, it's my belief there is a cost for not taking action. And I think that's demonstrated even 20 years ago when we had federal oversight because we failed to act. And for that reason, I'm here before you. Mr. Chairman, committee members, I'll stand for questioning.
Thank you, Director. Appreciate that. Good morning, Senator Case. Good to see you. Committee, again, this is a bill that we spent quite a bit of time on during the interim, but any questions for the Director? Go ahead, Senator Furphy first, and then Senator Schuler.
Thank you, Mr. Chairman. This change that we're proposing, it does say the Department of Corrections Investigation Services Unit. Hearing what you just testified, are you concerned that we keep the term the Department of Corrections in there? Or are you okay with this change in the language?
Mr. Chairman, Senator Furphy, I don't really have a concern with that. However, it could be misleading to think that the Department of Corrections is protected by this act then. But it was our way of identifying that it's specific down to 7 individuals through an investigative service unit. So that's why it was identified as the department. But it would not include the Department of Corrections, excluding criminal information, gang intelligence, or security procedures developed by the investigative unit.
Senator Schuler?
Thank you, Mr. Chairman. My question, on the bottom of page 1, where it talks about the custodian may deny the right of inspection on the grounds that disclosure to the applicant might be contrary to the public interest. Could you provide an example of that, when that might occur?
Mr. Chairman, Senator Schuler, Major Ricel, do you want to provide a copy of that? If I may as well, while the Major's looking, you want to provide examples how information gets out even though we redact it?
Sure. Mr. Chairman, Senator Schuler, so oftentimes what happens
Can you
is...
do me a favor, just for the public, can you introduce yourself again for us? Thanks.
My apologies. My name is Major Tim Ricel with the Wyoming Department of Corrections Investigative Services Unit. I manage that unit. So what we've found over time is that the inmates in the criminal network is vast. We see all kinds of different communications that go out to civilians who may not have any sort of criminal background. That information is passed through family members, through associates, et cetera, to other associates that may have nefarious activity and intent. One example we had a serious assault. It took place, I think it was 2012 or so. And through that, there was a release of information that took place. It was a 3-on-1 assault that took place at the state penitentiary, pretty serious assault. We had to transfer people out of state as a result of that. And what happened is that that investigation was released to the assailants. Through that, they determined who told on who. And from there, we actually discovered a plot in 2015 when I took the gang position. We discovered a plot that an individual who we had protected by sending out of state was actually being sought for another assault by associates they had in a different state. So it's all interconnected, and it's very hard to track, and we do our best, but that's where that public safety, because it includes more than just people that are incarcerated. It includes those on supervision as well as civilians.
Senator Schuler, good. Any other questions of the director? Senator Case.
Thank you very much, Mr. Chairman. I apologize for being late. Mr. Chairman, I've never really been able to get here on this bill, so, but could we go over whether Corrections Investigative Service Unit are law enforcement or not?
Senator, I don't remember that conversation during the interim, but Director, can you help us with that?
Mr. Chairman, Senator Case, thank you for your question. They are not law enforcement, but they are post-qualified service office. And the approach under this bill specifically talks about security information, gang intelligence, and the protection thereof. And that's the work that they do daily. Major, you want to answer?
Mr. Marcel, you have anything to add to that?
Yes, Senator, Mr. Chairman, Senator Case. I would also point out that by state statute, we have law enforcement retirement, and then we are post-certified through the Wyoming Law Enforcement Academy. I think the distinction is that we're not sworn.
Okay, Senator Case, go ahead.
Mr. Chairman, I think that's the distinction I'm looking for, actually. The other exceptions in here seem to be people that are sworn and have this obligation, and I don't doubt anything about the facts behind this, Mr. Chairman, but I don't see all the qualifications. Is there more to this bill than just is right here? Because it says that this unit and its investigations and files is going to be exempt from public records disclosure. And that's a blanket thing, the two people that are not law enforcement. And that's where I have trouble. We could make them law enforcement, or we could qualify the things that they can keep close to the vest. But you know, the world is full of examples of government units gone bad. And I don't mean to be dramatic here, but these are very interesting times. And the public protection, I think, is served by disclosure, except for when we don't. You know, there are definitely exceptions. This doesn't talk about sections. That says these group of people that have this function, in other countries, they might wear these uniforms or belong to this entity. They are exempt from public records. And I can't go there.
Well, I think that, thank you, Senator, and that comes right to the heart of the policy question for us. This was not unanimous out of committee by any means, but it was something supported, and that's what we're all going to have to decide if the bill goes forward. Any comments on that, Director?
Mr. Chairman, Senator Case, we're not asking for the exemption that the information is not provided. The information is provided now, and we follow the Public Information Act where material is redacted. And even under that redacted form, we have people being assaulted. We're a small agency, and it doesn't take much to figure out. You can't redact a unit, or it doesn't take much to figure out. So then in turn, we house people out of state. We have to accept individuals from the receiving state back to us, and they're not sending padres to us that are doing right. With that being said, what this would provide us an opportunity is an in-camera review where we can determine, we don't make any determination. We can provide the courts a judiciary review. So the information is not being hidden. And one other thing I would like to indicate, I mentioned prior to your arrival, we have over 1,000 reports per year, and less than 7% are even referred to the IU. Any form of criminal activity behavior, it goes to our county prosecutors. These reports, these investigations, what the prosecutors utilize. We're not using the county, the sheriffs and stuff. The prosecutors are using our reports to prosecute that type of behavior. And with that in mind, if we choose to do nothing, which we can in the past, I believe if you look at the state auditor and there are other people on that list, it really talks about information that's for security purposes and intelligence. And that's what this unit is completely designed by, as I mentioned earlier, because of a federal court consent decree that we had, because we didn't protect the information and people were being assaulted. So it's not that we're hiding the information. That was in when, Tim, 2000, the Skinner case?
2002.
In 2002, we had federal oversight. We were in a consent decree for 7 years because we didn't have a mechanism for reporting and investigating and turning things over to prosecutors, and people were being assaulted. So we're doing everything possible not to go down that pathway again and make sure our people are safe, our staff, our inmates, things of that nature. So thank you for allowing me to comment.
Thank you very much, Mr. Chairman. I do understand the gravity of this and the importance. I'm just looking for one more step, either qualifiers in the law, or a review by someone outside the agency, maybe Attorney General. I'm looking for the safety valve to make this work, but also have it not be I don't know, to have an extra set of eyes perhaps look on it, or limits under the law that allow those extra set of eyes to.
Thank you, Senator. Any other questions of the Department of Corrections this morning? Any
Mr.
other
Chairman,
questions?
may I make a comment?
Absolutely, Mr. Barstow, go ahead.
Mr. Chairman, Senator Case, I would also like to make a comment regarding the current statute. It does include the state auditor's office, so I believe there is that distinction of people who are not sworn already. With regard to the relief valve, I think that's very important. We do have a judicial review process. The ombudsman can review all of these for, as well as the district court. So there is a relief valve in place already with the current statute.
Thank you. Appreciate that reminder as well. Senator Case and I actually worked on that statute a couple of years ago, and we're proud of that effort. So thank you, gentlemen. Appreciate it. We're gonna keep moving this morning and go on to some public comment on this bill, or anybody else who'd like to testify on the bill. Is there anyone else in the room that would like to testify on Senate File 35? Is there anyone online raising a hand? Okay. Once more for public comment. Anybody for public comment? Okay, public comment is closed. What's your pleasure on the bill, committee? Moved by Senator Cooper and seconded, and we're not going to need a second from this point forward, but it would have been seconded by Senator Schuler. So, discussion, committee. I think I would say this. I think that Senator Case has hit on something that certainly could be revisited. If this bill moves forward and added to our statutes. There's nothing that says that our Judiciary Committee or as individual senators, we couldn't revisit this and tighten this down a little bit. But I'm inclined to support just simply based on safety concerns that I have in our prison population. Go ahead, Senator.
Thank you, Mr. Chairman. No, it's just interesting to me that they have the city auditor listed on here. Is there any reason for that? Because again, they wouldn't be certified, full certified, would they? I mean, just a question.
Sure.
Curious.
Yeah, we didn't have any testimony in that regard during the interim, but I would assume that there are financial transactions that probably have to be protected, but I'm only guessing on that. So, anything? Go ahead, Senator Case, and then back to Senator Cooper.
Mr. Chairman, at the appropriate time, I'd like to offer an amendment.
Okay. Please take it away.
My amendment would be line 7, page 2, after the comma, after department, insert the words, upon approval by the Attorney General, Department of Corrections Investigative Service Unit. And I don't literally mean the Attorney General, I mean the Attorney General's office, so, yeah.
Okay, so does everyone understand the amendment offered by Senator Case? Okay, we're on line 7, after the word department, comma, upon approval by the Attorney General, comma, the Department of Corrections Service Unit, et cetera. I'm gonna ask a question, Director. Hopefully you're following what that suggested amendment is. Any concerns over that time constraint? Do you see any problems with having that approval structure in there? It feels like, Director, that you could get on the telephone, contact the Attorney General's office. Feels like you could get approval in a pretty expedited fashion. What do you think?
Mr. Chairman, I have no objection to Senator Case's amendment. My goal here is to provide public safety.
Okay, thank you very much.
Thank you.
Okay, any other discussion on the amendment? Okay, all in favor of the amendment, say aye.
Aye.
Any opposed? No. That amendment has passed. We're back on the bill. Senator Cooper, I think you had a comment.
Thank you, Mr. Chairman. I was going exactly where Senator Case went, so take care of my comment.
Okay, good deal. Are we all set? Anything else on the bill? Okay. Mayor, would you please take roll on Senate File 35?
Senator Case,
No.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon.
Aye. Committee, does anyone have a desire to carry this one up on the floor?
I'd give it a shot, Mr. Chairman.
Yeah, I'm looking for someone with a little more enthusiasm. Senator
Got a lot of
Case.
enthusiasm.
There you go. Just misguided a little bit, you know what I mean? So I do have a favor to ask, Director, whoever carries it, and it looks like it might be me. I would love to talk you out of some notes. I really appreciated your comments this morning. They were very helpful, and if you'd be willing to share those, redact anything you want out of them, but that'd be helpful. Okay, Director, thank you so much. Appreciate you being here. Okay, so Senate File 35 will go to the floor for consideration up in the Senate. Let's go on to Senate File 30, Influencing Jurors and Witnesses, Judge's Amendment. Committee, you will remember that we spent quite a bit of time on this issue in the interim, and wound up, quite frankly, with this bill as a substitute. And you remember that there was a little bit of heartburn that it wasn't listed on the agenda of the third meeting. but this was brought forward from the second meeting as a substitute bill to at least get this issue in front of the Senate. So is there anyone here who can, who wants to testify on Senate File 30? I thought so. Ms. Butler, thank you for being here. We would appreciate any comments you have on Senate File 30.
Good morning, Mr. Chairman, members of the committee. My name is Elisa Butler. I am the State Court Administrator for the Wyoming Judicial Branch. This was a small change, as you all remember, during the interim to include judges in the statute that prohibits intimidation of jurors and witnesses. The reason for this bill really was a discomfort that we heard from judges and possibly from prosecutors that that statute did not specifically or explicitly include judges as one of the people who, should not be intimidated. And so this was really a result of that and the fact that prosecutors wanted some more clarity in terms of bringing prosecutions against folks who did intimidate judges. So a couple of things for you all just to keep in mind. I wanted to provide you with some statistics of what we've been looking at over the last few years when it comes to threats against judges. So the U.S. Marshal Services reported that threats and other inappropriate communications targeted judges and other court personnel rose from 926 in 2015 to 3,706 in 2022. That is a 300% increase. In Wyoming specifically, between 2015 and 2023, we saw a 166% increase in reported security incidents in courthouses across the state. And so this is becoming a bigger problem over time. The reason that it is important is that when you think about the judicial branch, it really is the cornerstone of our democracy. It's designed to be apolitical and insulated from outside pressure. And that's to ensure that its decisions are in accordance with the rule of law. When people can intimidate the judiciary without fear of prosecution, that insulation essentially evaporates, and it puts the structure of the judicial branch at risk. So, Mr. Chairman, the judicial branch is fully in support of this bill. We would appreciate your support as well. And if you have any other questions that I can answer for you, I'd be happy to do so.
Thank you, Lisa. Appreciate it. Any questions of Ms. Butler this morning? Go ahead, Senator Schuler.
Thank you, Mr. Chairman. Just a question. I remember we heard from a couple of judges. Do you see this happening more at the district level? Where are the threats usually taking place, just out of curiosity?
Mr. Chairman, Senator Schuler, it really is across the board. We hear it at all levels of the court system. We don't necessarily hear it from the municipal courts because they're not judicial branch courts. But I think you heard a story from one of our circuit court judges who had a bomb threat. And so, there was a prisoner who said he had somebody that he plant a bomb at her house. And so she was up in the middle of the night searching her house for a bomb. And so that was a circuit court judge. We've had district court judges who've had defendants show up at their houses, just out of the blue. It's becoming more and more of an issue. Obviously, the Supreme Court, we get a lot of mail, a lot of phone calls based on, and a lot of it does increases during the time of a high profile case. So yeah, it's across all jurisdictions.
So Ms. Butler, do you anecdotally have anything for us with respect to, we had some really compelling testimony from our female judges in particular, and that was concerning to me. It sounded like that we have been leaning on our sheriff's departments a little more heavily these days. When we've got judges afraid to go to their car at night, that's concerning.
Mr. Chairman, yes. We would be happy to provide you some additional stories. There are many, many stories out there. Specifically with female judges, I think what we have heard is they do experience increased threats, intimidation, those kinds of things, and sometimes of a sexual nature, which is, hitting at the heart of what we want to prevent. So it is something that happens daily in the courts. And as I said, those incidents are reported incidents. There are many, many that are not reported. So it's an underrepresentation of the actual incidents in our courthouses across the state and across the nation.
Yeah, appreciate that. Thank you. Any other questions of Ms. Butler this morning? Okay, thank you so much for being here. We may come back to you with another question a little bit later.
Thank you.
Is there anyone else who would like to testify on Senate File 30 this morning? Please come forward. Absolutely. If you would state your name for the record for us this morning, and welcome.
Thank you, Mr. Chairman. My name is Mark Aronowitz, Director of Lawyers and Advocates for Wyoming, public interest law firm based in Jackson and not-for-profit as well. Wanted to speak briefly in favor of Senate File 30. Two powerful quotes from members of your committee so far. These are very interesting times and afraid to go to their car. I was reading the legislation, read this, was quite surprised that jurors, witnesses, and officers were covered and judges specifically weren't. Maybe they are as officers, and that's why the caption says clarifying, but to put the specific word in there, judges covered during these times and these days, I think is very important and wise and good. And then I would add one thought that I'm concerned about is the final few words in the discharge of his duty. So you mentioned afraid to go to their car. What if something happens in the parking lot after court is done for the day at 6 o'clock at night, and the defense to intimidating a judge is, well, he or she wasn't in the discharge of their duties. Court was done, the gavel happened. Jurors at the end of every single trial are like literally discharged from their duties, but we live in small towns, we see each other all the time. Something can happen in the parking lot, grocery store, hockey game, when they're not on duty anymore. And if you threaten or attempt to intimidate a judge at the grocery store on a Saturday, that seems just as bad as in court where there's much more protection and security. So just something to think about to make this even more effective. You may not run into a witness until a month later, but for the statute to accomplish its goals, just something for you all to think about.
Thank you for that, Mark. I appreciate it. I hadn't really gone there, but you bring up a very good point. I do have a question, and it's in regard to concerns that some of our colleagues had, which was the absolute right to, during an election process, for example, to indicate to folks why they don't think a judge should be retained. And I think there was some concern that this may, that you could run afoul of this statutory language if you were merely writing a letter to the editor to explain why you don't think a judge should be retained. I don't think that happens with this bill. I don't share that concern to that level, but as it goes forward, what are your thoughts? What are your thoughts in that regard?
Mr. Chairman, great question. I think the first part of that statute, by force or threats, covers that. I mean, I could say, I don't like this judge. I don't think this judge is wise. I don't think they care about the facts or the law, and I think there's got to be a better candidate. And there's certainly no force or threats there. That's just my opinion, but I haven't threatened to do anything to the judge. So I think you cross a line of, if you reelect this person, I'm going to do something bad, and now you're in this statute.
Sure. Any other questions, committee? Go ahead, Senator Case.
Mr. Chairman, I think this is a pretty good discussion, and I appreciate it. I think that could cut both ways. If you have to be, what if a judge is your neighbor? And I'm just going to get an extreme, and you're fighting about something as neighbors sometimes fight about. And something bad happens, and you could be charged under this statute if we remove the relationship to the duty. And let me throw something at you. It says in discharge of their duty, which I agree with your point, that is physically doing this job. But what if we said in relation to the discharge of the duty? So that it doesn't actually have to be during the course of the duty, but they're being threatened or intimidated as a consequence of the duty that they undertook and the aftermath of it. And I'll just throw that out. Because that will affect every other people. It's not just the judges.
That's exactly right. And I like where you're going, Senator, because I think this is a really good conversation. Appreciate it, Mark. You brought this up, and I think it has a lot of merit. So, that may not be quite honed in there, but I like where you're going. So when we work this bill, maybe we can find a way to capture this whole idea of a judge simply trying to get to her car in the parking lot. Because you're exactly right. By that point, the work is done, right? Any other questions? Thank you so much. I appreciate you being here. We may ask you a question later. Okay.
Thank you, Mr. Chairman.
Is there anyone else who would like to testify on Senate File 30? Please come forward. You would state your name for the record for us, and welcome. Appreciate you being here.
Morning, Mr. Chair, members of the committee. My name is Beth Lance. I appear here today on behalf of the Wyoming Trial Lawyers Association. Our association of more than 350 attorney members in the state of Wyoming support this bill. We all, or many of us, have heard of stories related to types of threats against judges or have been unfortunately privy to them directly. I myself had a case where I was a prosecutor on behalf of the state of Wyoming, and I had brought a termination of parental rights case. And through the course of that case, on the morning of trial, the parent that I had brought the case against issued a bomb threat to the entire courthouse. And it was a stressful situation, I think, for everyone in the courthouse, but especially the judge. At that time, it was District Court Judge Couts, who is now on our Supreme Court. And so these things have happened for many years. And it is something that just has been missing in our law. I think potentially the thought probably initially was that these type of threats mostly come in criminal cases where the decision maker is a jury. But in reality, we're seeing these kinds of threats in family law cases too, which often then the decision maker is the judge. And so there's an attempt to intimidate or threaten the judge as the decision maker there. And additionally, we're starting to see with this current political climate, cases coming out of even our Supreme Courts, right, where we wouldn't necessarily historically have seen these potential kinds of threats, which now with the divisiveness and these tough decisions that our appellate courts are making, we're seeing, I think, more and more issues even at that level. So certainly our membership would support this legislation. Mr. Aronowitz's comments are well taken. I do feel that there could be some clarification here that I do think would assist. However, I also think that there is very good language in there early on, not only force or threats, but also that force or threat is an attempt to influence or intimidate, right? And so I think the question that was raised as to speaking out under your First Amendment right towards retention of a judge would not fall under an attempt to influence or intimidate the judge on any specific case, right? As long as your comments were simply, this judge, is not the best judge, we shouldn't retain them. I don't feel that you would be falling under that definition within this as it's written either. And I would stand for any questions.
Thank you for your testimony. Appreciate it. Go ahead, Senator Schuler.
Thank you, Mr. Chairman. My question, I guess, would be the language I think that Senator Case mentioned. How do you feel about that, where we add, if we were to add that, or an officer in relation to the discharge of their duty, does that make it more clear? Does it add a little bit more layer of security outside of the courtroom? And how do you feel about that?
Ms.
Mr.
Lance, go ahead.
Mr. Chairman, Senator Schuler, I think it is a good piece of limiting language there that I think does tend to make it more clear. If you are a judge and you are going to your car, right, you're still in the process of your workday, arguably, right? And so that is in relation, I think, to the discharge of your duty. You would not otherwise be in that property, the vicinity of the courthouse, your office, all of that. So that does seem to create that tie.
Senator Case, go ahead.
Try. Ms. Lance, I always appreciate your point of view. I wanted it to be broader than that, though. So the judge on Sunday is stopping at the grocery store on the way in. He's not, there's nothing to do with being in court. He's not going to his car, or she's, it's not really connected to performing, but it's because he's a judge, and that there's someone that's angry at him or her because of the duty that they perform. So I just want to be clear that the language I'm thinking is that broad, and I'm hoping it would be interpreted that broad, so that it's not just like the stop sign on your way to court or going home from court. It's more like, because you're a judge and the person is aggrieved for some reason because you're a judge and doing these duties.
So Ms. Lance is one of our trial lawyers. Would you be able to prosecute a case like that in relation to your duties, is what we're saying in the statute? You're at the Safeway store and an incident happens that, like Senator Case just alluded to. Is that language good enough?
Mr. Chairman, it's hard for me to necessarily be able to say definitively, just without spending maybe more time on this one. I think certainly an argument can be made, but I do question whether with time there could be even stronger language that could be thought of to make it more foolproof for our prosecutors.
I want to go back to Senator Schuler. Go ahead. Any follow-up?
Oh, no, sir. Thank you.
Senator Case?
I throw that language out as the working piece.
Ms. Lance, thank you very much this
Thank
morning.
you.
Appreciate it. Thank you.
You want some water? I think there's some back here.
Oh, thank you. Anyone else want to testify on Senate File 30 this morning? Anyone else? Anybody else? Is there anyone online who would like to testify? Is there any public comment? Any other public comment? Okay. Committee, I'm going to close public comment so that we can work this bill a little bit. It sure feels like we've hit on something that would help this bill in my view. So thank you, Senator Case. Really appreciate that. So Senator Case, we've closed public testimony, and we'll work the bill. I liked where you were heading with this, so maybe you could, if you'd be willing to take a stab at this on page 2.
Yes, Mr. Chairman.
Oh, yeah.
Sorry, just making sure.
Thank you very much. The bill was moved by Senator Schuler. So let's work the bill.
Mr. Chairman, I would just suggest that on page 2, line 3, the beginning of the sentence, we add the words relation to, so that that clause, it applies to all of the officers, impeded juror, judge, witness, or officer in relation to the discharge of his duty. The his duty, that's old language, everybody. It's just the way it is in the law.
Okay, Pierre, do you have that? Discussion. Go ahead, Senator Cooper.
Thank you, Mr. Chairman. I wonder if we should consider a couple more words there, or as a result of. I think maybe in relation to does cover it, but in relation to or as a result of, would that help that at all, or?
That'd be friendly.
I'm looking out at some of our legal minds.
Is it just too many words?
It, in relation to or as a result of,
It's just a suggestion. I don't know if it'll help or not.
anyway, that feels a little unwieldy to me. It
Yeah,
feels
okay.
like maybe we, Senator Cooper, maybe we stick with in relation to. And the challenge for all of us, I'm looking out that way too, is to see if there's something we think might help this bill on its way through, if it passes this morning, okay? I think we can all continue to think about this one. But I would say maybe from my standpoint in relation to, let's stop right there. So that's the proposed amendment.
So
Senator
I will
Case.
withdraw the friendliness of this so that we're back on relation to.
Okay.
I've suddenly become very unfriendly.
Yeah, all of a sudden it wasn't very friendly. So, so the in relation to, before the word the on line 3 here, and I again apologize for this chest stuff that won't go away. Anything else on the amendment, everybody? All in favor of Senator Case's amendment, please say aye.
Aye.
Any opposed, no? Okay, that amendment has passed. We're back on the bill. Anything else on the bill, committee?
Question.
Okay, question on Senate File 30. Pierre, would you please take roll on Senate File 30?
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy. Aye. Senator Schuler,
Aye.
Chairman Landon.
Aye. Okay. Who would like to take this one? Senator Schuler?
It's simple.
Thank you very much.
Happy to do it.
Oh, I think it'll be simple.
Yeah. What we always say when they turn complicated.
And just if we take a moment to remember the history of this, we had a different bill in the interim.
Yes, we did.
And Representative Crago proposed this, which was a much simpler solution and seemed to be better received by the committee than that other bill.
So, and just before we leave this topic, committee, I've thought a lot about this, and I think it's one of the more important policy concerns that will come in front of the legislature this year. I think in a broader scope, I often find myself concerned about what's going on in terms of the judicial branch and what it's up against these days, and it's concerning, very concerning. If you lose the rule of law, we know what happens after that. So it's touched us in our little state of Wyoming, and I think we need to stay diligent on the Judiciary Committee and keep an eye on this. We may need more down the road to make sure that people understand that we need to take care of our judiciary branch. So anyway, thank you very much to all who testified. Good job, committee. Let's move on to Senate File Senate File 2036, Uniform Child Abduction Prevention Act. Ms. Butler, would you have any comments on this? Would you like to come forward and remind us of anything here, or no? Are you good?
Mr. Chairman, members of the committee, Elisa Butler, I'm the State Court Administrator for the Wyoming Judicial Branch. This bill was not actually something that was suggested or recommended by the Judiciary, and maybe Ms. Lance may be able to speak to it a little better than I can. The only thing that I would mention, and I think this was the testimony that I gave when this bill came up in the interim, and that is there's some language in the bill that requires an emergency hearing within so many days. And I think I brought to this committee's or the full Joint Judiciary Committee's attention that when there's language like that in a bill, it does add an extra burden to our judges. And that's just something to keep in mind. If everything becomes an emergency, then nothing is an emergency. And so that's just one thing that our judges noticed in the bill. But other than that, Mr. Chairman, I don't know that I have much information to give, and I believe Ms. Lance would be in a much better position to provide you better information about this bill than I.
Appreciate the chairman, appreciate it. Ms. Lance, we would appreciate any help you can give us with this bill.
I'm not, is your microphone on, sir?
My apologies. Ms. Lance, if you would join us. I didn't have my microphone on, so I'm repeating that.
Morning again, Mr.
Yeah,
Chairman.
yeah,
Beth Lance, attorney in Cheyenne and with the Wyoming Trial Lawyers Association. This was a bill, obviously, that was worked on by this committee through the interim. It is a bill that is appealing to family law attorneys. Essentially, anyone who's practiced family law for any period of time has had a parental objection occur in a case. And this outlines, I think, some really excellent guidelines for our courts, for tools to make specifically available to them to assist families that have this situation occur where their children are removed from one parent. And so certainly to that extent, it is something that family law attorneys in general support and WTLA would support.
So, Ms. Lance, is there anything specific in the bill with regard to those remedies and et cetera that you would point to that I do remember that there was a caution thrown out with regard to putting time limits there. I know that is hard, but on the other hand, this topic deserves important attention quickly, doesn't it?
It does. It is something that, as I stated, does come up. I think the idea of just giving the judges all of this ideas for things that they can do to prevent this from happening is just so helpful. Things such as travel restrictions, restrictions on passports, those things are really helpful in a case in which signs are there that a parent may be looking to abduct their child from the other parent, things like that we often see. So I do think that there are good tools here that I think would assist in some cases in prevention.
So I guess, and as well as all of us here on the committee, there are those who prefer that we do nothing, that we, by golly, that's parents and they can work it out and they can take their kid anywhere they want to go. And so that's what we come up against with bills like these. Any words of wisdom on that front? Why should we pass a law this sweeping that restricts?
Mr. Chairman, certainly there are cases where we have seen where potentially one parent is extraordinarily mentally ill. Children may truly be in danger. That parent may not be either caring appropriately for the children and or, not taking them to school, not doing regular things that a parent should do. I spoke with another family law attorney, and that was the exact situation she had, where a father was really severely mentally ill and obstructive with children for almost a year, was completely off the grid with the kids because did not enroll them in school or do anything like that. And so obviously very scary time for that other parent. And she, as an attorney, certainly felt quite frustrated with the lack of being able to, get things in place that she felt should have been in place earlier. The signs were there with this parent that was a possibility that he would abscond with the children. And so I think this act would have been really important in that case and would have certainly been helpful to those kids, obviously the mother as well, but for sure those children to not have had to go through what they went through in that situation. So we do have extreme cases too, such as that. Obviously not everything's that extreme, and I don't know even, this isn't going to come up in every case, of course. But it is something that the ABA, the American Bar Association, is who came up with this. 16 states have now adopted this Uniform Act. 6 states have it pending in their legislatures this year. So I do think this is an act that most states are seeing as valuable for their attorneys in their states. And so I think we'll continue to see it being enacted state by state.
Okay, thank you. Any questions of Ms. Lance? Any ponderances? Okay. Thank you, Ms. Lance. Really appreciate it. Anyone else like to testify on this bill? Please come forward. Please state your name for the record and welcome. Appreciate you being here.
Thank you, Mr. Chairman. My name is Alan Thompson. I'm the Executive Director of WASCOP, the Wyoming Association of Sheriffs and Chiefs of Police. And Mr. Chairman, if I may, I'd like to give some input. I don't have a definitive amendment or suggestion to the committee, but some considerations from a law enforcement perspective. If you look at page 20, line 23, it starts the section on law enforcement actions in what are appear to be totally a civil process. And Wyoming statute from the law enforcement standpoint, when it comes to executing search warrants on private residences, rely solely on searching for evidence of a crime. And search warrants for the arrest and apprehension of personnel suspected of committing a crime also authorize entry into residence. This would be a new concept that, unfortunately, I wasn't on board with WASCOP in May when you guys discussed this in the Judiciary hearing in Sheridan. And it's kind of been a new concept that we've been researching pretty consistently since then and trying to find how that how the protections of civil liability and so forth would work with enforcing a civil warrant, essentially, to allow us access to a building to seize a child and place the child into protective custody. And I struggle
Thompson,
with.
Excuse me for interrupting, but can you take us to that specific page again? I missed where you were.
Yeah, let me confirm that real quick. So if you look at page 20, line 23, it's the very bottom of the page, and that's just the heading.
Okay.
And then page 21 in entirety, page 22 in entirety, and half of page 23 cover that concept of an issuance of a warrant to place the child, take the child into protective custody. I would like to say on behalf of WASCOP and the administrators that I've talked to, we wholly support the concept of this process to protect children that are at risk of being abducted. But the mechanism to enforce that from a law enforcement standpoint does cause a little bit of concern. And I've been discussing with our attorney and some people that have worked these cases. Myself, I've worked one of these horrible cases that lasted 5 years. When I started the case, I was a sergeant, and I was the second one to have it. And by the time the case had resolution, I was the sheriff, and 6 years had passed. So with all that said, we're just trying to wrap our mind around how this concept of issuance of a civil warrant gives protections of the liability of the officer. Because if you can imagine, the authority for an officer to enter a building under exigent circumstances in the middle of the night could be or will be some of the most dangerous things that we encounter, not only for the officer, but for the people in the house, including and especially including the child. I do believe the language in there allows and authorizes, it doesn't demand. But in my experience, we've seen orders that are issued from the court that indicate that law enforcement shall, and that puts us into a rough position because we then carry that liability as the enforcement of the court order, and that liability is not borne by the court or the issuance. And I wish I had a better answer on how to succinctly address that in here. To have some references to Wyoming State Statute 62204, which is the criminal interference with custody. And I know that this bill is, we're pondering this bill because 62204 is sometimes too high of a burden of proof, and we want to prevent that abduction from happening to begin with, so that there isn't application of 62204 in criminal prosecution. So I'm just not sure. I have suggestions of maybe an amendment to indicate that law enforcement acting on behalf of the court, pursuant to any order issued by this section, shall have immunity from civil and criminal liability, so long as the officer acted within the terms of this act and in accordance with the court's order. But I also understand that, that appears to issue a get out of jail free card for bad actors, and we don't want that either. So, sorry, Mr. Chairman, but I just wanted to make sure that those concerns were noted, and if we can come up with something that actually addresses that and gives balance, we'd be happy to provide that, but we're just kind of not at that point right now.
Mr. Thompson, thank you. We did have some powerful testimony and some heartfelt visits with our public on this one. Boy, and good thoughts this morning. This is a tough one. This is, anytime we come into this arena, this is some of the toughest work that all of you do out there. Really appreciate it. So, committee, any questions of Mr. Thompson this morning? Law enforcement. And by the way, our condolences for the loss of one of your colleagues yesterday. We're all heartbroken on that front. So,
thank you, Mr. Chairman.
Thank you for being here, Mr. Thompson, and we reserve the right to ask you a question later, okay?
Thank you.
Anyone else want to testify on Senate File 36? Any other testimony on Senate File 36? Is there anyone online who would like to? Okay, one more time for public testimony. I'll close public testimony. Committee, what's your pleasure on this bill?
Move the bill.
Senator Cooper moved the bill. Let's talk about this bill, committee, and we can work it through page by page if we want to. The question in my mind is it ready? Are we ready to go upstairs with this bill? It has received a lot of work and obviously support in several states. I think there will be a lot of questions on this bill as it comes out on the floor. So, and rightfully so. I think that people need to know exactly what this law is going to do. I think the concerns issued by Mr. Thompson are noteworthy because if there's concerns by our law enforcement out across, that could make it tough to garner the support we need to carry this bill forward. So, Senator Cooper.
Thank you, Mr. Chairman. I think this bill is going to take a lot of discussion, a lot of time to bring forward, and I'm not sure in a budget session that this is the right type of bill to be bringing forward. I have a few questions on it myself, and I'd really like to see this bill continue as an interim bill rather than being brought forward at this time.
Any other thoughts? Senator Schuler.
I'm kind of on the fence with this, Mr. Chairman. I like the bill. I think it's probably something that, 16 states have already adopted. I'm sure it's they've probably really done their due diligence on it. I am concerned about the part with from 20 to 23 with the law enforcement. It seems as though that where, it says that they may enter a private property to take custody of the child. I think that you may authorize them. I think that might help with liability issues, which I'm sure that, our policemen that was their biggest concern. It would be mine as well. But again, if I could go either way, if Senator Cooper made a good point that maybe we need to do a little more study on it as well. So I'm on the fence.
Mr. Chairman?
Senator Case.
Well, I'll throw a different curveball. I mean, things are dying like crazy around here, and this might be one that dies, but, if you look at the makeup of our committee, we don't have any of those folks that hate this kind of bill on this committee. And it might be a good idea to just take it up there and run it with them and get their input, and maybe it's going to fail. But that would teach us a lot about what we would have to do in the interim to make it a better bill. And failures, losing a bill is not the end of the world. It could make this a better bill down the road. On the other hand, we might get people thinking about the issue, and this is an important issue. Children are in danger. Spouses are in danger. Other people are in danger. And the world is just getting a little bit more crazier every day. And the violence is more acceptable in a way, or more revered by some. And so I'd say, let's run it up there. And it's fourth and long yardage, and let's go for it.
Always appreciate your courage and your
I get a lot of credit for that.
and your wisdom.
Not much for success, Mr.
A
Chairman.
little bit of wisdom there, but a lot of courage too, Senator Case. We like that. No, I appreciate those, all of those comments, committee members. I feel pretty strongly that that we need to represent this part of the world, and this, no question, is important stuff. I remember the testimony up in Sheridan was just so compelling. I mean, what a terrible case that was, and Ms. Lance, you really outlined several things. It's really, really helpful. Yeah, I appreciate too, Senator Case, you reminding me that losing a bill is not the end of the world. It sure feels like it, but so I think we take a roll call on this, and unless there's any other comments on the bill, do you want any amendments that we want to offer this morning on this bill? Anything else? Any further comments? Okay, Mayor, take roll on Senate File 36, please.
Senator Case,
Aye.
Senator Cooper,
Aye.
Senator Furphy,
Aye.
Senator Schuler,
Aye.
Chairman Landon,
If I say aye, I have to carry it up on the floor, don't I?
I think so. Case.
Aye. But I'm assigning this bill to, does anyone want to be really brave and take it up on the floor?
How about making a team effort?
I like that idea. We can decide when we get upstairs, folks, but I would appreciate any help someone would like to give, and would also appreciate, Ms. Lance, any notes that you would have. Your thoughts were very helpful this morning. Mr. Thompson, likewise, really appreciate the thoughts you gave us this morning and would love to have any comments you have. And we'll try to represent all of that, as we go up on the floor. This is, it's important stuff because this too is a part of the world that's continuing to change and get a little more difficult. And well, I sure think of our officers going to front doors more today than I did yesterday, that's for sure. Well, thank you all for being here. Committee, we will likely take up a couple of sex offender bills on Friday. I will confirm that with you. We also have the hemp bill that's on our side that we need to take that up. I'm inclined to probably take that one up on Monday, just so that everyone kind of knows when things are coming. So we have several other bills that have been referred to us, and it will be up to leadership to let us know what kind of traffic they want on these bills. Some we may not want to consider right away because we've got a lot of bills in the hopper. And so we'll have to listen to leadership on that. But anyway, so that's where we are. We'll head upstairs with 3 good bills this morning. Appreciate everyone. We're adjourned for today.
Thank you. Cool.
Thanks, Gail. Thank you, Coop. Nice job. Senator Schuler, Furphy, good job.
So